before this Reorganization Act was placed before the House, the entire constitution was made applicable. Therefore, that proviso goes. Now, what Article 3 your lordships have applied, my lord, when this reorganization took place. But I hope I am able to make myself clear. What was shown was the earlier constitution as applicable to Jammu and Kashmir, Article 3 as applicable to Jammu and Kashmir, which provided for a mandatory consent. But first, the president issued 272, CO 272, applied the whole constitution, meaning thereby what we are reading now as Article 3 was Article 3 when reorganization took place.
What's the date of reorganization? What's the date of reorganization?
It was passed on 6th of August. In both houses. Lord, this is Berubari is considered. Lord, Berubari, your lordships are aware, my lord, has no application. A part of India was being ceded to some other country. That was the concept. That was the fact situation arising in Berubari. There was a mistake in Berubari, which 5-judge bench in Ram Kishore notes and corrects. And thereafter, there is an amendment to the constitution, knowing that now there was a mistake in Berubari. I'll show, my lord. Please come to para 91 at page 164. Only, my lord, the relevant parts I have quoted and I'll read. This is a 5-judge bench, my lord, speaking to my Lord Justice Gajendra Gadkar. Before proceeding to deal with the points which have been raised before us by Mr. Mukherjee on behalf of the appellants, it is necessary to advert to the opinion expressed by this court in re the Berubari Union and Exchange and Enclaves, so and so. The Berubari Union at para so and so, with a view to correct an error which has crept into the opinion through inadvertence. On that occasion, it was urged on behalf of the Union of India that if any legislative action is held to be necessary for implementation of Indo-Pakistan Agreement, a law of Parliament relating to Article 3 of the Constitution would be sufficient for the purpose, and that it would not be necessary to take any action under Article 368. This argument was rejected. In dealing with this contention, it was observed by this court that the power to acquire new territory and the power to cede a part of the national territory were outside the scope of Article 3C of the Constitution of India. This court then took the view that both the powers were essential attributes of sovereignty and vested in India as an independent sovereign republic. While discussing the significance of the several clauses of Article 3 in that behalf, it seems to have been assumed that union territories were outside the purview of the said provisions. In other words, the opinion proceeded on the basis that the word state used in all the said clauses of Article 3 did not include the union territories specified in the first schedule. Apparently, this assumption was based on the distinction made between the two categories of territories by Article 1(3). In doing so, however, the relevant provisions of the General Clauses Act were inadvertently not taken into account. Under Section 358B of the said Act, state, as respects any period after the commencement of the Constitution, 7th Amendment Act, shall mean a state as specified in the first schedule to the Constitution and shall include a union territory. This provision of General Clauses Act has to be taken into account in interpreting the word state in the respect of clauses of Article 3, because Article 367(1) specifically provides that unless the context otherwise requires, the General Clauses Act shall, subject to any adaptations and modifications that may be made therein, under 372, apply for the interpretation of this Constitution as it applies for interpretation of an act of legislature. Therefore, the assumption made in the opinion that Article 3 in its several clauses does not include union territory is misconceived, and to that extent, the incidental reason given in support of the main conclusion is not justified. My lord, after this judgment, my lord, 18th Constitution Amendment is made. Judgment is, my lord, 27th August 66. I'm sorry, the judgment is 1965.
What is the date in 1965?
My lord, I'll just give the lordship may give me a minute. The amendment is, my lord, 27th August 68.
27th August?
66. 27th August 66.
And just give us Ramkishore's.
By which, my lord, these explanations came to be added.
Right.
That state
explanation.
includes UT. That was, my lord, result of this Ramkishore Sen judgment. My lord, if your lordship would like to see where it is PDF volume, I'm sorry, volume 6, case compilation
For
volume
what?
6,
For what? Ramkishore judgment.
Ramkishore judgment. Your lordship wanted Ramkishore judgment?
Yes, sir, just the date. Just give us the date, that's all.
My lord, 11th August 1965.
All right.
This is prior to. the-
Now, your lordship, my lord, kindly directly go to Lord, your lordships have seen page 167, the view of Justice Khanna, my lord, Justice Khanna, Delhi High Court. And thereafter, my lord, I'll read Mangal Singh little later because it's not, my lord, quoted here. Please come to 169, page 169. State of West Bengal. And read only the highlighted part. Now, my lord, I am confining to highlighted part. My lord, your lordships, only, my lord, note, my lord, there is some typo. 1964 1 SCR, page number is not mentioned, my lord, 371. You can correct. Page 169, citation. 371. May I answer? Look, this is a judgment by 6 honorable judges bench. The legal sovereignty of Indian nation. Your lordship, guess, my lord, justice call, my lord, para 101.
101.
The judgment is, my lord, State of West Bengal versus Union of India.
Yes.
Legal sovereignty of the Indian nation is vested in the people of India, who, as stated by the preamble, have solemnly resolved to constitute India into a sovereign democratic republic for the object specified therein. The political sovereignty is distributed between, as well as we will presently demonstrate, the Union of India and the states with greater weightage in favor of union. Kindly come down, my lord, to para 35 of the judgment, only the underlying portion. There are no independent constitutions of the states apart from the National Constitution of Union of India. Chapter 2, Part 6, from Article 152 to 237 deals with states, the power of legislature of the states, the power of executive and judiciary. What appears to militate against the theory regarding the sovereignty of the state is the wide power with which the parliament is invested to alter the boundaries of states and even to extinguish the existence of a state. There is no constitutional guarantee against alteration of boundaries of the state. By Article 2 of the Constitution, the Parliament may admit into the Union or establish new states on such terms and conditions as it thinks fit. And by Article 3, the Parliament is by law authorized to form a new state by redistribution of territory of a state or by uniting two or more states or parts of states or by uniting any territory to a part of the state, increase the area of any state, diminish, etc. Then 4 lines from thereafter, Parliament. The word starts with Parliament. Parliament is therefore by law invested with authority to alter the boundaries of any state and to diminish its area so as even to destroy a state with all its power and authority. That being the extent of the power of parliament, it would be difficult to hold that the parliament which is competent to destroy a state is on account of some assumption as to absolute sovereignty of the state incompetent effectively to acquire by legislation designed for the purpose of property owned by the state for government purposes. Then next is, my lord, again, Babulal Parate is 5 judgment. But Babulal Parate, this is different, my lord, not that 19(1)(a) judgment. That is also Babulal Parate, my lords, recollect, my lord, freedom of speech and expression. Lord, here, views, my lord, the assembly's views were taken from Bombay Assembly for ABCDE areas. And when the Reorganization Act, I'm sorry,
Yeah.
Act was passed, my lord, it was some additional areas were also, my lord, therefore that was under challenge. We proceed now to consider these contentions. It is necessary to state at the outset that our task is to determine on a proper construction the true scope and effect of Article 3 of the Constitution with particular reference to second condition laid down by the proviso thereto. We bring it to our task such consideration as are germane to the interpretation of an organic instrument like the Constitution, but it will be improper to import into the question of construction doctrine of democratic theory and practice obtaining in other countries unrelated to the tenor, scheme, and words of the provision which we have to construe. Lord, kindly come to the later part, my lord. Article 1 of our Constitution, Lord, somewhere in the 10th line from bottom of
Yes.
170. Does your lordships get me?
Yes.
Article 1 of our Constitution says that India is a union of states and the territories thereof are specified in the schedule. There is therefore no difficulty in understanding what it meant by expression state in Article 3. It obviously refers to states in the first schedule, and the legislature of state refers to the legislature which each has under constitution. That being the position, we see no reason for importing into the construction of Article 3 any doctrine, consideration of the sanctity of rights of states, or even for giving an extended meaning to the expression state occurring therein. None of the constituent units of Indian Union was sovereign and independent in the sense the American colonies or Swiss cantons were before they formed their federal unions. The Constituent Assembly of India, deriving its power from the sovereign people, was unfettered by any previous commitment in evolving a constitutional pattern suitable to the genius and requirement of the Indian people as a whole. Unlike some other federal legislatures, Parliament, representing the people of India as a whole, has been vested with the exclusive power of admitting or establishing new states, increasing or diminishing the area of an existing state, or altering its boundaries, the legislature or legislatures of the states concerned having only the right to an expression of views on the proposals. It is significant that for making such territorial adjustment, it is not necessary even to invoke the provisions governing constitutional amendments. Then, my lord, Raja Rampal, only one line, my lord, I'll now coming down to one line, my lord, kindly, my lord, appreciate. It says India is an indestructible union of destructible units. Raja Rampal, my lord, again, 5-judge bench. law, my lord, I am pointing out. I am not pitching that argument that high, my lord. What we have done is, as a temporary measure, as it is clear from day one, the parliamentary debates, that we have created two units, namely two union territories, and one union territory is with legislature, the power vested with the power of police with the center. Because of the very peculiar nature of the situation arising since decades. Rest everything they have, what state has.
Pointed out two instances where it has happened. The first was Punjab. That was a very peculiar problem. Punjabi Suba movement, etc. More or less everybody was agreeable, probably it could not muster through the legislative assembly.
No, there was no assembly.
The
It was during governor's rule.
No, I understand that, but earlier it could not muster through the division of Punjab between Haryana and then parts of Punjab going to a union territory first, even Himachal Pradesh, then Himachal Pradesh itself becoming a state. And then probably Cochin and Travancore is the other example which is given. The third is this. This is a way, because once you suspend the proviso, then virtually the power of the state governments are taken away. The representation of the state is represented by
Page 173. Where the court considers what is the scope and ambit of the state's views. That's why I'll, rather than paraphrasing, I'll read. Lord, kindly see SR Bromai, para 108. Lord, para 108, my Lord, just is called page 173. I have quoted SR Bromai. Lord, last 4 lines on that para. But I'm trying to rush, my Lord, so that I can finish. Your Lordship gets on a conjoint reading, my Lord. My Lord Justice Khanna gets on a my Lord Justice Suryakant and yes. On a conjoint reading of these articles, it becomes clear that Parliament has the right to form new states, alter existing states, or the name of any existing state. Thus, the Constitution permits changes in the territorial limits of the states and does not guarantee their territorial integrity. Even names can be changed. Under Article 2, it is left to Parliament to determine the terms and conditions on which it may admit any area into the Union or establish new states. In doing so, it has not to seek the concurrence of the state whose area, boundary, or name is likely to be affected by the people. All that the proviso to Article 3 requires is that such cases the President shall refer the bill to the legislature of the states concerned, likely to be affected, to express their views. Once the views of the states are known, it is left to Parliament to decide on the proposed changes. Please, my Lord, note, Parliament can, therefore, without the concurrence of the states or states concerned, change the boundaries of the state or increase or diminish its areas or change its name. These provisions show that in the matter of constitution of states, Parliament is paramount. This scheme substantially differs from the federal setup established in the United States of America. So, my Lord, it is in substance, in my respectful submission, said that it's a provision which is strict compliance is not insisted upon, provided there is a broader compliance, namely the entire nation, considering that this affects the nation as a whole. This situation doesn't affect the state only or neighboring states only. This affects the entire nation and therefore including representatives of Jammu and Kashmir. Parliament and Rajya Sabha, Lok Sabha and Rajya Sabha have representatives of Jammu and Kashmir. These are my judgments on 3 and 4. Would your Lordships like to have a bird's eye view of the Act?
All right.
Lord, volume 3, documents, page 112. I won't take more than, my Lord, 5 minutes to do this. I am, my Lord, tempted to show this because nobody has shown which could not have been my objection, but without showing several statements were made that we are reduced to nothing, everything is taken up. Therefore, my lord, it is my duty to point out just bird's eye view, my lord. Page 112.
Volume 3.
Volume 3, document volume 3, my lords. Page 112. But please see definition, assembly constituency is defined 2C. It has all attributes of a state. It is state with UT with legislature, but all attributes of a state. Assembly constituency, your lordship gets 2C. Am I with your lordship?
Yes.
Then election commission 2D, then 2G, my lord, on the next page, 113. 2G legislative assembly, J population ratio and union territory. Please, my lord, see the formation of union territory of Ladakh without legislature. Then, my lord, formation of union territory of Jammu and Kashmir with legislature. Correct, my lords? Then come to, my lord, page 114. No reduction. My lord, they say that our representation in parliament is reduced. On and para 10, my lord, on and from the appointed date, there shall be allocated 5 seats to successor union territory of Jammu and Kashmir and 1 seat to union territory of Ladakh in the House of People. Earlier they had 6. Now it is 5 plus 1, 6. Then
Did you get that?
delimitation of I'm sorry.
That's section 10.
Section 10, my lords. My lord, the argument of Mr. C.U. Singh was that we have lost representation in parliament. Then somebody said that our seats are reduced. My lord, Mr. Nafde said the seats are reduced. It was 6 in total. Now it is 5 Jammu and Kashmir and 1 Ladakh. Then, my lord, 12. Every sitting member of the House of People representing a constituency which, on the appointed day by virtue of the provisions of section 10, stands allotted with or without alteration of boundaries to the successor union territory of Jammu and Kashmir or union territory of Ladakh, as the case may be, shall be deemed to have been elected to the House of People by that constituency as so allotted. So they continue as Lord Lok Sabha members. Then 13, all and from the appointed day, the provisions contained in Article 239A, which are applicable to Union Territory of Puducherry, shall also apply to the Union Territory of Jammu and Kashmir. So, my lord, now, my lord, this is amended. My lord, this is amended. What is placed is not amendment. My lord, I'll just place your lordship, my lord, the copies of the amended act. I'm not reading from this act, my lord, I'll give copies to the other side also. Because this has all the acts which are made applicable, which were not applicable, central acts, including beneficial legislation. And suitable amendments in the local acts. Local acts are retained if they are not repugnant to the central acts, with suitable modifications, making them constitution compliant. Well, this is amended, para 30, section 13, because the argument was that now we can't vote. MLAs of Jammu and Kashmir cannot vote. Lord, at page 10, foot of the page, section 13. My Lord Justice Gawai and Justice Suryakant has that. Page 10 of this book, my Lord. Amendment is in this book, therefore, my Lord, I am. Page 10, right side, left side, top is the pagination. Section 13. On and from the appointed date, the provisions contained in Article 239A or any other article containing reference to elected members of Legislative Assembly of the state, which are applicable to Union Territory of Puducherry, shall also apply to Union Territory of Jammu and Kashmir. So they can vote, my lord, wherever MLA is required to vote. In, for example, the example given by petitioner was presidential election. Then 14, my lords. I have one copies. Section 14. There shall be an administrator appointed under Article 239A of the Constitution for the Union Territory of Jammu and Kashmir and shall be designated as Lieutenant Governor. The total number of seats in the Legislative Assembly would be 107. Then, my lord, every entry except police. Police is, my lord, now for obvious reasons, my lord, I need not even explain why police is, my lord, directly under the control of the center. My lord. And clause 6, my lord, this comes for the first time. 14.6. This was never there. Seats shall be reserved for scheduled caste and scheduled tribes in the Legislative Assembly of the Union Territory of Jammu and Kashmir. This has come for the first time. Then come to, my lord, section 16. Lord, earlier only permanent residents could contest elections under section 16. I'm not inviting your lordship's attention to read it. Now, he should be a citizen of India. He need not be a permanent resident for being qualified to be elected, my lord, like any other state, my lord. My lord, please come to the relevant entry, my lord, the relevant section, my lord, is at page 119, bottom, section 32, extent of legislative power. Lord, subject to my answering your lordships about the election on, my lord, day after, when, my lord, in the morning. But
119 of your compilation or?
no, my lord, the act,
That's
volume 3, my lord, same act, I'm reading from the act, my lord, page 119, section 32. Volume 3, document volume 3, my lord. Your lordships have 32. Subject to the provisions of this act, the Legislative Assembly may make laws for the whole or any part of the Union Territory of Jammu and Kashmir with respect to any of the matters enumerated in state list, except the subjects mentioned at entry 1 and 2, namely public order and police, respectively, or the concurrent list in the 7th schedule to the Constitution, insofar as any such matter is applicable in relation to Union territories. Then, my lord, 35, inconsistency between the laws, my lord, there is a provision. Special provision as to
So
finance.
follows the Delhi model. Delhi model.
Has led.
Delhi, of course, 1 and land. 1, 2, and 18 is carved out. Land is given to the state legislature.
No, land is not given.
Not given. Where is land accepted? Which provisions is land taken away?
Not here, not here. Here only police and public order.
Right.
But in Delhi.
I thought you were saying land is also taken away.
No. In Delhi, it is public
1 to
order,
8,
police.
And 1, 2, and 18.
1, 2, and 18. Your lordships, Lord, we have troubled your lordships for a long period, my lord, on that. I wanted to avoid that part, my lord, but it is.
It's argued so many times that even
yes.
1, 2, and 18 stuck like a mantra in the brain, you know. So.
But here, my lord, 18 is not there, my lord. It is only public
1,
order
2.
and police.
Yeah, public order and police.
And for, my lord, reasons obvious. The very object and purpose of reorganization is this. Well, thereafter, there are financial bills provisions.
One more change. Parliament has competence on all the 3 lists.
That is because of 239 AA. Not, here it's not there.
So unlike a state legislature, in the case of union territories, like Delhi, for instance, Parliament can enact a legislation on any item,
No, that is because of 239 AA.
double A. But I'm
Here-
saying the same principle is followed here.
I don't think, my lord.
It is,
Subsection
Here
two.
239,
see, subsection 2, nothing in subsection 1 shall derogate from the powers of conferred on Parliament by the Constitution to make
yes,
laws
yes,
with
yes.
respect to any matter for the union
so, my
territory.
lord, that 239 AA provision is incorporated in the statute. Your lordships are right. My lord, there is a consolidation, for consolidated fund, my lord, which Mr. C.U. Singh said it's not, it's taken away. Annual financial statements, audit by the CAG. My lord, this is a official language, my lord. For the first time, there is an official language, my lord. I wish this was pointed out to your lordships, my lord, while saying that we have been deprived of everything. It's just a UT. It is a state, my lord, for all purposes except these two entries. I'm not going into the minute details, my lord, but it's a. Lord, Mr. C.U. Singh argued that the assets are also merged with Union of India.
Actually, nothing turns on it in this case. It's almost like trivia right now. But clause 2 says nothing in subsection 1, 32, shall derogate from the powers conferred on Parliament by the Constitution to make laws with respect to any matter for the Union Territory of Jammu and Kashmir or any part thereof. So this provision does not empower Parliament to make a law on the state list.
Like 239 AA.
The provision comes in 246(4). 246(4) says
Yeah, yeah.
Parliament has power to make laws with respect to any matter for any part of the territory of India not included in a state, notwithstanding that such matter is a matter enumerated in the state law.
No, that is at par
That's
with
why,
everyone.
that's why, no, just as a matter of constitutional position, Parliament can enact a law on all the three lists for Jammu and Kashmir.
Even in absence of subsection 2, it could have.
That's right, that's Article 246(4).
Constitution operates.
That's a constitutional position.
So I'm not reading, my lord. Mr. C.U. Singh, my lord, said that even the assets will go to, has gone to the central government. So there is a specific